can recall, before this moment, I laid what we call in law an evidential foundation on why the incumbent DG of NIMA should be properly addressed as His Excellency. And drawing strength from that solidly laid foundation, it's my pleasure to recognize His Excellency, the Director General of NIMA, Professor Oluwatunde Lawal Salako, ably represented by an eminent and Amazonic Director of Research, our dear Professor S.I. Smith. Welcome back. The only member of the National Institute, MNI, in NIMA today, who happens to be the Director of Administration, is in our midst today, ably represented by Mr. N.M. Butus, Deputy Director of Administration. Welcome, sir. All the management staff of NIMA here present, heads of departments and units, the directors and deputy directors, and indeed all NIMA staff that are here today. You are all welcome. By way of a background information, before the DG declares the training open, this training we are conducting today is a statutory requirement. The Freedom of Information Act of 2011 was passed into law by a former president of Nigeria, Dr. Goodluck Ebele Jonathan, in the year 2011. And what's the essence of the act? The essence of the act is to give Nigerians the right to access certain information that are within the domain of public institutions. And not just public institutions, even private institutions that utilize public funds. Prior to the enactment of the Act, Nigerians did not have such right to meet any public institution and demand for some information. When the information wasn't given before the enactment of the Act, the applicants did not have local standard. By local standard, I mean legal right to challenge such a refusal in court. But with the enactment of the Act, when an applicant meets a public institution and requests for information, when the information is wrongfully refused, such an applicant can access the court for remedies. Just some time ago, a civil society organization approached NIMA and requested for some information pertaining how NIMA conducts its activities as a public institution. Unfortunately for them, the information they requested fell under the exempted information that a public institution is not meant to disclose. What does that go to say? It means that in as much as Nigerians have the right to request for information, it's not every information that is at the domain of a public institution that can be disclosed. There are exempted information that a public institution is mandated not to disclose to applicants. At this juncture, I think it's safe for me to stop here because the trainer will do justice to the act, lest I may be accused of hijacking the job of the trainer. Ladies and gentlemen, it's my pleasure to invite the Director General, ably represented, to declare this training open and for his remarks. The DG, please.
Good morning, everybody, and welcome to the training for today. Our able Director General, Professor Oluwatunde Lawal Salako, is unavoidably absent. He's busy outside on a research work, so he's asked me to represent him and convey his messages and his goodwill. So we welcome you to this training. And it's called the Training Workshop on the Freedom of Information Act 2011. So I believe that at the end of this training, everybody is supposed to be well equipped and armed to give a kind of step down on what you have learned here today to other colleagues in the department. So I want to welcome you here. I also want to thank the trainer school is here, we really appreciate and thank you for taking out time on your busy schedule to come here to train us. Thank you so very much. We appreciate you. And so, with these few words, I want to declare the training workshop on Freedom of Information Act 2011 open. Thank you very much. I'm so sorry I won't be able to stay to be with you because I have another meeting now. Just to show how important it is to me, that was why I had to leave my meeting to be here. So thank you very much. I wish you a fruitful deliberation. Thank you.
You can do more than that for the people of Africa. Ladies and gentlemen, without much delays, I wish to invite the trainer. Before I do that, before me is an abridged citation of the trainer. The trainer is Kenechukwu Agwu, Esquire. He's an associate, Chartered Institute of Arbitrators, United Kingdom. He's a member of the Nigerian Institute of Management. He's a Master of Laws. He's a legal practitioner licensed to practice in Nigeria by the Supreme Court of Nigeria. He's also a consulting partner at ASK Legal Services. There he leads a team of experienced and dedicated lawyers with client-focused service delivery goal to provide a full array of legal services, including high-risk litigation and commercial transactions, alternative dispute resolution, statutory compliances, real estate advisory, property management, labor and industrial relations, legislative and legal drafting and advisory, corporate trainings and consultancies, and more other things. He also serves as an executive secretary at Sabi Law Foundation, where he co-anchors the Sabi Law on the beat 97.9 FM Abuja, a free legal radio show of Sabi Law Foundation. Kenechukwu Agwu Sunday Jr. was a project officer at the Network of University Legal Aid Institutions, NULAI, Nigeria from May 2018 to January 2022. As project officer, he provided technical assistance to over 43 university-based law clinics in Nigeria under the NULAI network. He worked with the team in developing and supervising projects with particular emphasis on pretrial detention, access to justice, street law, student law practice, legal aid and community justice education. He has also received training in clinical legal education nationally and internationally. His interest in clinical legal education was aroused when he served as the head of EPSU Law Clinic as an undergraduate. He has previously served as an associate with Cordy Honor & Co., an Abuja-based law firm, in 2018. He joined OFY Lawyers and later on Baysville Chambers International as an associate. He's a certified arbitrator in Nigeria and the United Kingdom. He's a member of Global Alliance for Justice Education and the Nigerian Institute of Management. He's a member of the Unity branch of the Nigerian Bar Association, where he served as director of MBA, Abuja Tech Law Clinic from 2019 to 2020, and a member of the Disciplinary Committee and the Lawyers Mentorship and Privilege Committee from 2020 to 2022. He currently teaches law of evidence, social justice, clinical education, moot court practice and ethics at the Bayes University, Abuja. He's also the administrator of the Bayes University Law Clinic. He has authored so many articles in both local and international journals and has presented papers at conferences within and outside Nigeria. Ladies and gentlemen, with a round of applause, let's make welcome Kenechukwu Agwu Jr. Esquire.
Good morning, everyone. Thank you very much. A special thanks to our DG, His Excellency, according to my little brother. For when we came to train the heads of departments and heads of units as the first part of the statutory training on FOI. SMC, oh, okay, sorry. The first part of the training was for them. And by the time we came, there was a ranking. That was the 2020 FOI ranking in Nigeria. We searched through that ranking and the institute was nowhere on the ranking. But after the training, the institute took steps, and by 2021 ranking, which came out earlier this year, the institute has now been ranked. So please, let's put our hands together. So the institute is now ranked the 35th position out of 215 institutions and NGOs. From not being in the ranking to 35, please, it deserves a round of applause. And a couple of things that came out from the training helped this. So I'm very glad to be back here, and I'm so excited. So today we have a larger group, and I just want to make a request. The request is very simple. I am not a presenter today, I'm a teacher. And as a teacher, I prefer to go back to the classroom methods. So do we all agree that I am your teacher for this morning? Do we agree? Yes. Do we agree that as your teacher, I can direct you on what and what not to do? Yes. Do we all agree? Yes. Do we agree that I can ask you to stand and sit at will? Do we agree? Yes. Oh yeah, let's start from that. All stand. So when we are in school now, if they say all stand and one person does not stand at the same time, we'll do it again. So sit. Alright, let's do another one. All stand. Okay, we're going to take a song. We're going to take some fruit salad this morning before we proceed. And I'm going to break the class into groups of different fruits. So this group is going to be watermelon. This group, watermelon. The first 5 rows here will be papaya. Right? Then the other rows behind, and this group will be what? Which fruit you want to be? Banana, right? So when we sing your own fruits, you stand and the rest will sing. So we'll start by going watermelon, water. Every other person sits. One watermelon stands. All right, let's go. Watermelon, papaya, banana, fruit salad. Everyone will sing that. Is that okay? So have we gotten the song now? All right, let's try. 1, 2, go. Only the group will sing. 1, 2, go. At the same place. 1, 2, go. Banana, fruit salad. All right, thank you very much. Now, clap for yourselves, please. Now, the 3 groups, we are going to have a group leader in each of the groups. I will say something to the group leader and I expect him to pass it on to the group, right? At the end of the day, the last person in the group will give us back what was said to the group leader. It's just an experiment, and I will explain to you why we are doing that at the end of the day. So who is the group leader for watermelon? Who is the biggest watermelon? Who is the biggest watermelon? So they say the biggest watermelon. So we just passing the information. Who is the biggest papaya? Okay, please come forward. Who is the group leader for banana?
Hello, good morning everyone. My name is Adite Jabibola Mudupe. I'm in Watermelon, and the message is relax, lunch will come in good time, no cause for alarm.
My name is Mrs. Akinson. I'm here to represent Anti-Corruption and Transparency.
Then papaya that the information did not get because you can be right? Alright, so you are welcome. Have you registered? Can you register?
My name is Dr.
So I gave different information to different leaders, so don't think you can write on what you have said.
So I'm representing Team Papaya. The message is, it's not going to waste time, so take your time.
Alright.
Good morning, my name is Elika Deshelusoma from Banana. The lunch will take time. Exercise patience.
Alright, thank you. So, group leaders, did she get the message you passed? Yeah, yes. Okay. Did she get the message you passed the way you passed it? No, she missed out. Okay, she missed out something. Okay. Did she get the message you passed the way you passed it? Partial. So, who got it?
Thank you. I noticed that some groups did group passing.
Yes, that's fine.
So I know who knows.
The leader, what happened is that the leader decided his or her own method of leadership. And the people either accepted it or did not accept it. Now what happened with yours is that because he tried to use the singular information method, before it got to you, information has passed from one form to another, and it has been distorted, and it's no longer the same information. Whereas this leader was more transparent. She called all the group members and gave them the information at once. So what she said is no longer a function of what was said to her, but what she understood from what was said. It now becomes a perception issue and no longer the information passing issue. Do we get that now? Please, can we clap for them and clap for yourself? Oh, no, chose a representative method. So he spoke to him and he now went around speaking to everybody. That was also a different model that they chose by themselves. Right? Please clap for them. And then, in summary, let's prepare our fruit salad one more time. 1 to go. Salad, we are ready for the lectures now. Thank you very much. Clap for yourselves. Alright, so let's look at the background, meaning and importance of freedom of information. Right? We'll be looking at the meaning, the background, and the importance. What is the meaning of freedom of information? Freedom of information, in simple terms, is the right of the citizens to demand information. The access to information. It also includes demanding for sensitive information which are in the custody of public officers and public institutions. Now, according to FOI Act, when I say FOI, just know it's freedom of information. According to the FOI Act 2011, it is the right of any person to access or request information whether or not it is contained in any written form, which is in the custody or possession of any public official, agency, or institution. How did we get to requesting for information? How did we get to freedom of information? Previously, how many of us know what is called the Official Secrecy Act? The Official Secrecy Act was a law in Nigeria that made it impossible for you as a citizen to walk up to any organization, to any institution, and ask for any record. You ask them, even up until in recent years, the budgets of certain institutions were not known. If you go ask for it, they will refer you to Ministry of Finance. But the FOI Act says every citizen now has the right to request for information, to request for sensitive information. I deliberately included the word sensitive there, because these were information, pieces of information that were called classified. Information that were not supposed to be in public domain. Who can give me examples of those pieces of information that were previously called classified? Information you could not get from institutions. Yes?
Like the organization budget.
Let me pass the mic. Yes.
Organization budget.
The organization budget. Yes. Anyone else? Till Banana is winning.
Like probably salary of House of Senators or Representatives.
Salary of public officers. Salary of citizens. For instance, the FOI Act mandates that if I go to your website, I can find what the person in every grade level should be receiving. It doesn't say put the person's name and say this is what the person is receiving. But proactive disclosure mandates that when someone visits your website, if you don't have a website, there should be an office when we get to the organization that tells us people in this grade level receives this amount, people in this grade level receives this amount. Recently, the Pensions Commission were interrogated by the House of Reps, and they said they were spending how many billions on personnel. The House of Reps member said, please, what is this personnel? Do you mean to tell me that every staff here receives 2 million at the end of the month? And the woman was busy shouting, no, personnel involves training, it involves that, and I was just laughing. A simple disclosure on their website would have saved her that embarrassment. Are we on the same page? Yeah. All right. An example from this group, from Watermelon. Security votes. How much the governors received from security votes. Do you know that up until when Okonjo Iweala was Minister for Finance, Nigerians did not know how much we were going to the States every month. They just knew they would come to Abuja and collect their national cake and go. But Ngozi started by publishing every state how much they receive at the end of every month. They fought her. Why would you do that? How are they supposed to do that? This is public funds. It's not your personal money. These are some of the things that FOI intends to do. Next, please. I think Ms. Handy. Okay, I think I've even done a lot of things. Now, what we run in Nigeria is what we call the representative government, where you send people to represent you from the councillors to the House of Assembly members, to the House of Reps members, to the senators. Then we elect periodically people who will serve as chairmen, governors, senators, and the rest of that. If I ask us today, how many of us know the names of our councillors? Just put up your hands. I won't ask you the name. If you know the name of your councillor, we can verify it. We can verify it. If you know the name of your councillor, let me see your hand. 1, 2, only 2 persons out of everybody here. Okay, if you know the name of your local government chairman, let me see your hand. It's not working, but you know how many millions of naira your local government chairman go home with every month? How many of us are aware that some states have now gone into an agreement with the local government that when it comes, it's the local government money that they now use to do road construction? My state, for instance, that's the agreement my governor had with the chairman. So at the end of the month, the money comes to the governor in the guise that he's repairing his work, he's doing roads in the local government. So it's local government money. At the end of the day, the local government chairman cannot even fuel the big vehicles he has bought for them. All right, so prior to the enactment of the FOI Act in 2011, the difficulty in accessing information in the custody of the government was largely due to some of our laws, which guarantees the right to expression but denies us the right to access information. So the Constitution tells you it is a fundamental right to express your views. You have the right to expression, but it does not give you the right to request or to access information, right? If you look at Section 24, Section 36, and Section 39 of the 1963, 1979, and 1999 Constitution, respectively, they all provide for freedom of expression, but they do not give you room to access information. Now let's take a dive into the Act proper. The long title of the Act reads, "An Act to make public records and information more freely available, provide for public access to public records and information, protect public records and information to the extent consistent with the public interest and the interest of personal privacy, protect serving public officers from adverse consequences for disclosing certain kinds of official information without authorization, and establish procedures for the achievement of those purposes and for related matters." When you go to any law, to understand what the law seeks to do, you look at the long title. The short title reads Freedom of Information Act 2011. But this is the long title that tells us exactly what the Act wants to do, right? First is to make public records and information more available. For instance, it also says, if a secretary in the organization provides me with the budget for the organization, the CEO of the organization should not query that secretary for giving me that information. However, if the secretary also discloses personal information of the CEO to me, the FOI Act does not guarantee that. So you now see the reason why it is important for us to understand what can be disclosed and what cannot be disclosed. The importance of the FOI Act 5 importances. The first one is open participation. It gives you a sense of belonging. If you know how your organization is run, if you know how your state is run, if you know how your institution is run, it gives open participation. People can feel, oh, this is our organization, this is our own. It's what we own. So it gives us that sense of participation. It also helps for accountability. So if I know that the budget is in public domain, that the budget is in the website, I cannot go beyond what is in the budget. But if we don't even know what is in the budget, how do we expect to know? For instance, what I said to your group leaders, if they did not pass it down to you correctly, you will not know. But if, for instance, I have disclosed what I said to them, so if they were saying to you what was not what I said to them, you could stand up and say, no, this was not what was said. But if you don't know what was said, you would end up believing what you hear. And most times what you hear may not be the correct things. It also helps for transparency, it helps in record keeping. If you know that these records can be asked for at any time, it helps you keep your records clean and clear. It also gives accessibility to public records. Okay. Any questions? Yes. Put the second slide.
I just want you to expatiate on the fact that if the secretary discloses information and then the CEO cannot query the secretary, then it would be expected that that secretary should have disclosed that information following due process.
Okay. Yes.
That's one. Then the second one, we know that in every organization, maybe they are doing or managing keep personal information of personnel. So I think it's also important to be able to distinguish what we would refer to as personal information of personnel. Bearing in mind that if there is a request, for a disclosure and is related to personal information of the personnel or the staff, where do we have that demarcation?
All right.
What you can disclose as personal information and what you can disclose.
All right. Thank you very much. What are the topics we will treat? Okay, let's think about it.
Let me also clarify, because you give an example of the secretary. But ordinarily, the duties of the secretary does not involve that kind of information that has been disclosed. Is it really permitted?
Okay.
Thank you.
All right. Any other question? All right. Now, recall I said there's what we call proactive disclosure, right? The information that that secretary in that sense can give are information that ordinarily should be on your website. Public information, the budget. It's only the specific items that are not known, but the whole budget is known. So that information that we'll still look at types of information, public records and all of that. Information that are public records, that secretary can disclose. But information that has come to the knowledge of the secretary by virtue of probably being a confidential secretary to the CEO, you are not to disclose it. You are not to disclose personal information. For instance, something happened, my boss had some issues with the former institution where he was working, and the reason was that he gave his secretary his passport to go and photocopy for him. And the secretary saw all his traveling history. He's been traveling, going to UK, going to Canada, going to New Zealand, and the secretary went and ganged up with some people to write a petition that the man has been using the institution's funds to be gallivanting. The only thing that saved the man was that for each of those travels, they were funded by donor agencies, and they paid, and his memo seeking approval to attend, he kept those records. So by the time he brought it, it was clear. So it's no longer a case of, when they say whistleblower policy, even person with a blow whistle get limits. It's not everything that you carry whistle and blow. Your mouth will pain you. It will burst, right? So information that is not public information, you cannot just disclose it to anybody. And for clarity's sake, if you are not sure that it is your job description to disclose such information, refer the person to the FOI desk officer. The last time we came, we discussed with the DG that the institution should have a desk officer, which he made me to understand that it currently resides in the legal department. So if you are not sure whether or not to disclose, to avoid being sued for not giving information, refer the person to the appropriate quarters. That is also a form of information disclosure according to the FOI, which we will still study as we progress. I don't know if I've been able to clear those two questions. All right, let's go to the next. Yes, the second one. So in this session, we're going to look at citizens' rights to access information. It's no longer a privilege; it's a right. It's a right of the citizens. So if I walk into your organization and say, I need X, Y, Z, or I need the bill of quantity that was used to build this auditorium, you can no longer tell me who are you. Who are you to ask me for that? One governor in one state, I will call the name of the state, say, you don't know there is constituted authority. You don't know I am constituted authority. Nobody will ask you. There is the question of having the locus, like he said, does not arise. Anybody, any Nigerian can request for information. So you now see some NGOs who are looking for a job, who are looking for what to write against some institutions. They just start requesting here and there, even when they're not going to use it to do anything. But I'll tell you a story that makes us understand why this right is necessary. So our students were doing a project on the FOI. So what they did was go to the communities, talk to them about this new law, and tell them how it works. Then if they have any information they want to request, they help them put it in writing and have them put their thumbprint and they submit it to those agencies. So there was a particular village where they had contributed money. This is what they call counterpart funding. The community was to bring a certain amount of money and the government gave them an amount of money to build a market, right? Now, that market was not built for 4 years. And one woman raised it at that FOI session. So the students helped them fill the form and they submitted it. They took it to the king. Men and brethren, in 1 month, construction started in that market. So by the time they returned to get their information that they asked for, the king told them to go to the site and see that the work has started. So you can imagine that if those students did not go to that community, that king would have kept the money in his pockets and we all keep blaming Buhari. Remember, there was this kit that trended one time where passports, the head teacher told the child to bring 500 naira for, told the teacher that the students were going to pay 200 naira for passport. The teacher told the students they were going to pay 500 naira for the passport. The child went home and told the mom that we're going to pay 1,000 naira for the passport. The mom told the dad that they were paying 5,000 naira for the passport. And the father said, child, Buhari has finished us. So who is the Buhari in that instance? Alright, so we're going to look at pre-FOI and the FOI era. We're going to look at types of information that can be accessed. And we're going to look at bodies whose information can be accessed under the Act. Now, I've provided 3 laws here. Section 39 of the 1999 Constitution, Article 9 of the African Charter on Human and People's Rights, and Article 19 of the Universal Declaration of Human Rights. So I want someone from each of the group to volunteer to read out aloud to us each of these three laws that we have there. That's this, and this. So we start with banana. Anybody? Okay, there is this my brother who yes, please give him the microphone.
Just to read what is on the screen.
Okay, anyone else today?
39 of the 1999 Constitution of Nigeria, as amended, provides that every person shall be entitled to freedom of expression, including freedom to hold opinions and to receive and impart ideas and information without interference.
All right, thank you. Someone from this group read Article 9 of the African Charter. All right.
Article 9 of the African Charter of Human and People's Rights Ratification and Enforcement Act provides: number 1, every individual shall have the right to receive information. 2, every individual shall have the right to express and dissemination.
All right, now Article 19. I paraphrased Article 9 because it's very lengthy. You know, when you have this West African, when you have these regional instruments, their wordings are always very lengthy. So to save us, I paraphrased it now.
Article 19 of the Universal Declaration of Human Rights provides that everyone has the right of freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers.
Thank you very much. So, who can pick out a difference in these three? They refer to same rights, right? So, because Nigeria is a part of the Universal Declaration for Human Rights, we are made to make sure that our Constitution provides for this, right? And because we also belong to the African Charter, we're also a part of the African Charter, we are made to incorporate this. Now, in incorporating these two, we arrived at this. So, if you look at it very well, you discover that the people who drafted Section 39 carefully receive and impart, what does it say here? Receive and impart information and ideas. They carefully excluded information. So, and that made NGOs, civil society organizations, to say, why did we remove information? It's a fundamental right. So, in solving that problem, that is how we now came to the FOI Act 2011. God bless President Goodluck Ebele Jonathan. One of the laws, this is one of the reasons why they removed it. I'm not a politician, but I can tell you. This and the Same-Sex Marriage Prohibition Act. The Freedom of Information Act provides, improves on the lapses of the above provisions. Specifically, the Act establishes the right of any person to access or request information, whether or not contained in any written form, which is in the custody or possession of any public official, agency, or institution, howsoever described. By this, literacy or disability of any form can no longer be considered as a barrier to making these requests. Also, the Act allows for application through a third party. Like I said, those students were the third party that helped that community to request for that information. So it's no longer saying, oh, you are an NGO, what's your business? What's your business, what we are doing here? No. Anybody can request through a third party. NGOs can serve as those third parties that they can request the information through. Again, when the illiterate applicant makes his application orally, the FOI officer of the institution shall reduce the oral application to writing and provide a copy of the written application to the applicant. So you see that the job of the FOI officer is now increasing. It's not only supposed to give information. Where somebody walks in, a market woman walks in and asks for any information, his duty also is to reduce that request into writing. And we always advise them to have the person sign off on it or thumbprint on it. So eventually, when someone wants to say, why did you release this? Who asked you for this? You have a document to show someone actually asked for that information. Also, the applicant who intends to access this information does not need to demonstrate any specific interest in the information applied for, and he or she is entitled to institute legal proceedings in court to compel any public institution to comply with the act. So the court will not ask you, what is your own? Yeah, are you, is it Ajay Crowder or Mungo Park? Okay, is Mungo Park now, who came to the river where he saw people bathing, and saw people fishing and swimming, and say he discovered the river. He discovered the river. How do you discover a thing that people were really using? So the court will not ask you that you are no send. They send you. The act has said you don't need to have that locus to ask for it. Now, types of information that can be accessed through the FOI. The act further goes to define accessible information as all records, documents, and information stored in whatever form, including written, electronic, visual, image, sound, audio recording, etc. So for instance, this video recording that my good sister here is making of this training, somebody can walk in and say, oh, you did FOI training, I want to have the video. And you won't ask the person, what are you using it for? The person has the right to ask for that. Now, the act also goes further to interpret accessible public records to mean a record in any form, having been prepared or having been or being used, received, possessed, or under the control of any public or private bodies relating to matters of public interest, and includes any information recorded or stored or other devices, and any material subsequently derived from the information recorded or stored. Label marking or any other writing that identifies or describes anything of which it forms part or to which it is attached by any means. Book, card, form, map, plan, graph or drawing, photograph, film, negative, microfilm, tape or other device in which one or more visual images are embodied, so as to be capable, with or without the aid of some other equipment of being reproduced. So you don't say, oh, we don't have the printed copy. It's in the system. It's your duty to print it out and give the person. Oh, we don't have it. It was sent through email. It's your duty to print it out and give to the person. Now, bodies whose information can be accessed. These bodies are basically public institutions. The Act defines public institutions to mean any legislative, executive, judicial, administrative, or advisory body of government, including board, bureau, committee, or commissions of the state, or any subsidiary body of those bodies, including affiliate committees, which expends public funds, and private bodies providing public services, performing public functions, or utilizing public funds. I was just discussing with Nnamdi, and I said to him, before the courts went on vacation, we got a court of appeal judgment that supports this. Although the court agreed with us on this, but now went ahead to say that the Nigerian Bar Association does not fall under this body. So we are waiting to be briefed by our clients for us to proceed to the Supreme Court to properly interpret that. Because you cannot tell me that you agree with us that private institutions or other organizations that utilize public funds come under the purview of the FOI Act, and then you go ahead to tell us that NBA, which receives 40% of all the monies lawyers pay to the Supreme Court every year, is not a public institution by this definition. From the provisions of this Act, access to public information by any persons or the certainty of information that can be accessed is clearly guaranteed. Now I ask you a question. Does your institution, the Nigerian Institute of Medical Research, fall under our definition of public institution? All forms, then the request sent to them must be answered by them. See the case of Nigeria Foundation for Support of Victims of Terrorism versus the Coalition on ICC, Limited by Guarantee 2020. You can also see the case of Professor Juku versus the Nigerian Bar Association. Very clear on this subject. All right, any questions? We'll take her and then her. Start with her.
Okay.
Thank you for.
What are those obligations under the Act on Public Institutions? It is not news that for every duty there is a corresponding obligation. One of the duties of the public institutions is the enforcement of governmental policies at the various strata of government. By performing these functions, they get custody of several records and generate several data and are obligated to disclose such records and data provided they are not exempted. The nature of their obligation is in three first to NCDC. You also have obligation to make partial disclosure where justified, where you must justify your reasons for partial disclosure. Proactive disclosure, I've talked about it, but you are obligated to proactively disclose some information upon receipt of same or with or without request from the public. This form of obligation is mandatory, and where refused, any person can approach the court. The court can approach the court to mandate the public institution to do same. Sorry, something is missing there. The advantages of this is that it reduces the number of requests that would have been made to the public institutions. So for instance, where you have your vision and your mission statement and what the institution does and does not do on your website, it will reduce the number of people who will come here to ask you, what are you even doing here?
Yes, sir.
If they come, you know, we are just check the website. That was what the civil defense man was trying to do, that he lost his job. We remember www.nscdc. I cannot. How do we forget it so soon now? I cannot categorically tell you one now. Before I will say one, I'm my order at the door. If they had proactively disclosed, he won't run into that trouble. And Nigerians are wicked. That's how that man lost his job. Just like that. It's well known. Under the things you have to proactively disclose, I've talked about it, descriptive information, the list of things you need to talk about, then actual records of data. Under the list or enumeration of records, your list has to have classes of records under control of the institution in sufficient detail to facilitate the exercise of the right to information under this Act. Manuals used by employees of the institution in administering or carrying out any of the programs or activities of the institution. Files containing applications for any contract, permits, grants, licenses, or agreements. So after bidding is done, the files are left open for people to go and review. Files containing reports, documents, studies, or publications prepared by independent contractors for the institution, and materials containing information related to any grant or contract made by or between the institution and another public institution or private organization. Now, actual records and data. This is different from descriptive information and list or enumeration. It need not be made again once disclosed. In actual records or data, an applicant can make a request even after information has been disclosed. Documents that can be proactively disclosed. This is provided for in section 2, sub 3D of the FOI Act, and they include substantive rules of the institution, statements and interpretations of policy which have been adopted by the institution, final planning policies, recommendations and decisions, factual reports, inspection reports and studies, whether prepared by or for the institution, information relating to receipts or expenditure of public or other funds of the institution, the names, salaries, titles, dates of employment of all employees and officers of the institution. Note that there's no place they say date of birth there. I was training in one place and one man, I didn't know that they wanted to sack their director. Like the man went to falsify it. So the man told me, no, that date of birth is supposed to be disclosed. I'm like, date of birth is a personal information, right? It's not supposed to be what you proactively disclosed. It's not supposed, I shouldn't come to the website and see your date of birth there. It's even risky. Huh? On date of birth. Why?
Because of this constitution. It's one of the conditions in which people use that. So because people try to alter
It's just that now a lot of organizations are automating information.
We're also interested in not disclosing their age, right? When someone says he's 70 and the first daughter, don't be talking about, so that I can leave Lagos in peace. All right. The rights of the state, public institutions, or any of the private persons, and the name of every official and the final records of voting in all proceedings of the institution. The following points apply to all of public institutions' proactive disclosure obligations. 1. A public institution need not proactively disclose any of the 3 heads of information discussed above if it does not ordinarily keep that type of information, or if the information is exempted under the sections of the Act. If the institution does not ordinarily keep that record, there is no need to proactively disclose it. Of course, you don't disclose what you don't have. So it's records that you usually keep that you are expected to disclose. Information enumerated above must be widely disseminated in different formats. It may be print, electronic, or online, and I advise the best is to put it on the website where everybody has access to it. If you don't want to go, it's because you don't want to. And you know one thing they say, if you don't want Africans to know anything, put it in writing. Just say this thing is out there, then put it in 150 something pages. They won't read it. In fact, it even gets worse that I teach students and I give them cases to read, they don't read it. They go online and look for summary. So when I now come, I've devised the means of setting 30 OBJ questions from the case. So if you don't read that, you don't feel answer them. And we are the ones that say we are wicked teachers because we have asked to read. I don't know why we have. Anyway, we are also looking for ways of, since they have stopped reading books, to push the books to their phones, push the books to their emails, look for ways of making them read it. But in disclosure, it suffices that it is where the person can access it, that the person did not read it is his own cup of garden. Information to be proactively disclosed must be current. There is therefore a need to periodically review and update information meant for proactive disclosure. You visit some websites and you see that the name of the DG there is the former before the former. You visit some institutions, you will see that your rank, maybe you are a staff there and your rank there is the one when you were employed. They have not upgraded it. No, there should be a periodic review of these things to make sure they are current. You can find that in section 2 sub 5 of the FOI Act. There is obligation to proactively disclose is an enforceable right in the court of law. It is enforceable in the court of law. We cannot overemphasize this. Section 2 sub 6 of the FOI Act. When the request is made, after the request has been made, you must what? Promptly communicate decision to the applicant. After the request has been made, irrespective of whether it is granted or denied, I have said this, it is mandatory for the recipient public institution to communicate its decision to the applicant within the period specified under this Act. Such notifications must be made within 7 days. However, such period may be extended if it involves a large volume of information. Transfer application where necessary, I've also said that, and you have 3 to 7 days to transfer if the information requested is not necessarily from your organization. Now, the first institution must notify the applicant of his decision to transfer and must inform him, the applicant, of his right to have the transfer reviewed if he so wishes. The second institution is, however, expected to respond to the application not later than 7 days after it receives the transferred application. Section 5, sub 1 to 3 of the FOI Act. C. Make a partial disclosure where justified. This applies where the application of an applicant contains requests for both exempted and non-exempted information. The recipient institution has an obligation to make a partial disclosure. This consists in disclosing the part of the request not exempted while denying the part exempted under the Act. See section 18 of the FOI Act. General obligations. There are 4 general obligations. obligation to keep records, obligation to provide access to records, obligation to train staff on FOI, obligation to report to the AGM. I think I have discussed this when we had that chat, so I'll just skip that. So I think we'll move next to exempted and non-exempted information. What do we mean by exemption? Anybody? What do we mean by exemption? Not inclusive. Something. So for this, we are looking at information that are exempted. Information you don't need to disclose. Information you shouldn't disclose. Exemption means an official permission not to do something which otherwise one would have been legally bound to do. In other words, exemptions are limitations in the scope of information that can be requested by applicants. An exemption can relate to persons or things. Where relate to persons, it means the legal obligation, which ordinarily should attach to everyone, does not attach to the exempted persons. In this case of things, it means exempted things which may not be treated the way other items are treated. Simply saying, we may have exempted persons and we have exempted things. There are persons who you cannot request information from. There are some kinds of information you cannot ask, right? The essence of exemption is to protect public and private interest in such information. Under the FOI Act, an exemption is simply a valid reason for refusing to disclose information. It should be noted that unless a piece of information is specifically exempted from disclosure, there is no legitimate reason to withhold such information from the public under the Act. Thus, document marked as top secret or classified may still be disclosed to the public proactively or on request, unless it is shown that the document falls under any of the 7 exemptions under the FOI. How many exemptions? Everybody say 7. 7 exemptions. What is the effect of this exemption? The effect or implication of an information or record being exempted is that such information or record cannot be the subject matter of an FOI request by applicants or the public. Now, where a person requests for information under those laws that are exempted, you are also not allowed to just keep quiet. You must inform the person that this information he or she is requested for is exempted and therefore you cannot disclose. Reason: every human being has the right to human dignity, and it is degrading for me to ask you a question and you keep quiet. So you must reply. So your reply may either be to disclose, to say you cannot disclose because it is exempted, to partially disclose, or to transfer the request to the appropriate institution. Are we on the same page? Are we on the same page? So the days have gone where people walk into your office and say, "In my office," and the person is busy eating granola and banana. When we were in school, when you go to, especially when you want to do NYSC clearance, they will be eating granola. Man, tomorrow is the deadline. Is it today? The others started coming. Come on, leave me, let me finish. How can you be eating during work hours and sending away people who are coming for you to work? Those people are your customers. They are the king in this business. You are a servant. Whether it's a public or a civil servant, you are a servant. You are a boy. Do you understand? Those people tell you what to do and what not to do. And until we get that into our subconscious, our leaders keep thinking they are the bosses. They are only managers who we have hired to do the job for us. Every 4 years we change managers. But our problem is that when it's 3.5 years, they begin to send us wrapper, and send us rice, and send us garri, and give us awado. So when you collect those things, you are selling off yourself. And by so doing, you can no longer imagine where you hire. Let's take for instance, you hire a sales girl to work for you in your kiosk, and then This girl eats your money every time, but each time you say you want to sack her, she brings you one bag of rice. And say, don't worry, this time I will do well. And you say, okay. Will you retain her?
No.
Will you retain the person?
No.
But why are we returning politicians? Well,
and then they pay themselves.
but if they give you money, collect them. Now your money. It's your money. Ah, it's our job. Our law even says we cannot reject somebody who comes to you, except on certain ground. Not all of us. But if you don't put them here, we won't defend them. So please, ladies and gentlemen, I'm saying this to say we need to have, you know, there was one thing I liked about Dora Akunyili. Not when she was in NAFDAC now, but when she was Minister for Information. She started a movement for value reorientation. You know, it's because of Dora that our mama here can now wear Ankara to walk boldly. Before, she would look for a suit or look for a gown. But because Dora and Okojo is even worse, she just tie it. She doesn't have time, she just tie it and leave it there. But there was a value orientation to say, let's get Nigeria in good light first. That was when we started Savicom. People need to be served like human beings. Days are gone when people come to your hospital, come to your office, and you just hush at them and treat them the way you want. They are the kings. The customer is king. When I say this, many senior lawyers want to fight me. They say, hey, these small ones, I just started yesterday. How can you say that a client should come to my office and I now walk the person to the door? Say, who got you? They will sit in their office, even when they are not doing anything. They will tell you, oh, guy is busy, wait for him. When he's doing nothing. God will help us. Listen, I thought I was the only one pained by this thing. Thank you very much. So let's return to what we've talked about, effects of the exemption. Purpose of exemption is to protect public interest and private interest too. To protect public and private interests, right? Now, types of exemption. The FOI Act does not clearly classify exemption. It simply provides for information which may or must be exempted from disclosure, and information which may be exempted only upon fulfillment of certain conditions. However, a good perusal of the Act will show the following exemptions. 1. Qualified exemption. Say after me, qualified exemption. 2. Unqualified exemptions. 3. Injury-based exemption. 4. Discretionary exemption. And 5. Non-discretionary exemption. Now, okay, sorry, say after me. Everybody say number 5 again. I'm glad we are in class. You know how we learned A for apple? It's by repeating it. A for apple, B for ball. Now they've changed it though. I'm sure if you see any child in nursery school now, it's no longer B for ball. Just use style and watch those cartoons they watch. Parents, yes, sir, these are classes. I try to group them in classes. I will get to that. Thank you very much.
Please, if you are representing someone, endeavor to write your name against the person's name, so that certificate will be issued to you, not the person that didn't attend the training.
Yes. That's why it's called certificate. Anybody who is not here will not receive our certificate. Okay. Oh, they say food is set. Do we pause and go or finish this? Okay, let's finish this, then we'll go for lunch and come for the last one and certificates. That's fine. All right. Qualified exemption applies to the classes of information which may be denied by a public institution only after considering and satisfying the requirements of the public interest test. Some examples of the qualified exemption provided under the Act includes exemption of international affairs and defense, where such information will be injurious to Nigeria's defense, we will not disclose that. Section 11. Which is why when people were shouting that they should disclose the contractors Nigerian army use for buying weapons and arms, they will not disclose that. Because those people, if they are known, they can be compromised. Right? Account books, objects kept by an organization for records. The Act defines a public record to be a record in any form, having been prepared or having been used, received, possessed, or under the control of any public or private bodies relating to matters of public interest. It includes information recorded or stored on other devices and any material subsequently derived from information so recorded stored. It includes label marking or other writings that identifies or describes anything of which it forms part of. It includes books, forms, maps, photographs, negatives, microfilm, and the rest of that. So these, someone may ask, why did the law put them in these different categories, right? There is a method of interpretation in law that we call a jus dem generis rule. What means is, if I have listed book, card, form, maps, plan, graph, or drawing, it means anything in that family. Anything in the family of those ones mentioned, even though not mentioned, forms part of that. Right? So it is being specifically set out to avoid a situation where someone says, no, this is not a public record by our law. The thing is, we'll go through it and look at it and see, does it fall under any of these families? For instance, if I mention goats, dogs, sheep, what else are in that family? Cow. I'm confused if a cow is domestic animal. Cats. Cats can be domestic depending on the category of cats. We have wild cats. We have even rats. We have house rats and bush rats. Okay, but you get the idea. When you mention A, B, C and they're in the same family, it just means that D, E, F do not mention, but they belong to the same family, form part of that, yeah. Now, why should records be kept by public institutions? Let's think why. Why should public institutions keep records? Yes. Let me give to a record officer, IT person. Tell us.
To be able to access.
To be able to have access to it, okay? Why do we keep records? Why should public institutions keep records? Ma, for accountability, yes, I heard that. For reference purposes, yes?
Referencing.
For future reference.
And then if you want to display your productivity,
yeah,
what you have archived, should be able to showcase what you have been doing.
So that people can go and verify. So that people, nobody wake up tomorrow and say, okay, you know there was a time, right? My parents are both teachers and they happen to work in our state university. So there was a time EFCC came and they released list of professors. They say they ate 5 million, 7 million, 10 million, and people were wondering how did that happen. The only thing that saved my father was that the secretary was busy keeping records of those fuel they will buy and keep all those documents. So, you know, impressed, office impressed. That's how most people nearly lost their jobs that time. So record keeping is very vital. Record keeping is very, and anybody who wants to deal with you, when they know you don't keep records, that's when they can lie against you. Facts don't lie. People can say whatever they want to say, but the records are there. People can go and verify. And in these days of digital means of keeping records, we tell people, in addition to just keeping paper files, scan your documents and upload them in clouds. Save them somewhere. So that nobody will come and say, okay, when he was there, so money was missing. What did they use the money for? You might have actually used the money for official purposes, but because you've not accounted for it properly, it becomes misappropriation. It becomes a crime. They'll say you are corrupt. I know how they start. They start by going through people around you. By the time they pick everybody around you, when they now come to you, you don't have anything to say. Yeah, so records are kept for easy access to information when requested as evidence of activities and programs carried out by the public institution. Is the requirement of the Act that records must be kept properly. Governments can be held accountable for their actions if proper records are kept. There are legal sanctions for failing to keep records or to destroy records. In this aspect of destroying records, I remember one man who swallowed the whole paper in Nigeria. And it's in Nigeria that they told us that a snake and monkeys swallowed somewhere. So someone said, is it not better to become a snake? I beg you for that, see where I go swallow, go on and tell you. Oh, okay. Now, what are the effects of non-compliance with the Act? It is important to note that the Attorney General has an oversight responsibility to ensure that all institutions that are affected by the provisions of this Act are in total compliance, which is why every institution is expected to submit an annual report, an annual FOI report to the Attorney General, which is why the Attorney General also has guidelines on the FOI. As stated earlier, public institutions are mandated to comply with the provisions of the Act. Where this is not done, such public institutions and the public officers may be liable for civil or criminal proceedings. There was a time this institution was taken to court for not giving information. But since we started giving, since the officer started giving the information, I think Nima won that matter. And damages were awarded. So you see, it's either ways. If I don't have anything to request for, and I go and say, oh, I requested, and you did not, you know, any of the states under the Act, we can sue the institution for their civil remedies or even criminal remedies. For civil remedies, you get compensation, you get damages awarded to you. For criminal, it means that the officer can go to prison for it. An applicant that has been denied access to information may also apply to the court for a review of the matter within 30 days after the public institution denies or is deemed to have denied. That is 30 days after you have denied the information. When we say deemed to have denied is when you don't respond at all. After 30 days, the person can deem it that you have denied to give him that information. He can approach the court for a review of that. Section 20, 30 days. The application for review shall be heard and determined summarily by the court. However, the court shall take precaution, including when appropriate, receiving representations ex parte and conducting hearings in camera to avoid the disclosure of the court or any person of the information or other materials on the basis of which any public institution will be authorized to disclose the information applied for. The public institution concerned has the burden of establishing that the public institution is authorized to deny an information or part of it. In these instances, the court can order upon appropriate conditions that the public institution concerned should disclose such information requested by the applicant if A, it is determined that the institution is not authorized to deny the application for information, B, the institution is authorized to deny the information, but the court finds that there is no reasonable ground to deny such information in the light of the circumstance, or where the court makes a finding in the light of the where the court makes a finding in the something is missing there of the public that having the being made available is greater than and more vital than the interest being served if the application is denied in whatsoever circumstance. It is important to point out that no civil or criminal proceeding shall be brought against any officer or public institution or against any person acting on behalf of a public institution for the disclosure or non-disclosure of any information made in good faith. Where notice is required, there shall be no consequence flowing from a disclosure or non-disclosure, provided care was taken to required notice. In addition, no provision of the Criminal Code or Official Secrets Act shall prejudicially affect any purpose under these two. This provides like a whistleblower policy and covers that person disclosing the information. Conclusively, no civil or criminal proceeding shall be maintained against any person who receives the information or further discloses it. So you cannot also come to sue me that received the information or that passed the information. This part is simply protecting the whistleblower. You can blow whistle, you'll be protected. But if you overblow, and you... Thank you very much.
Ladies and gentlemen, you can agree with me that it has been a fruitful day. And NIMA can now beat its chest and say that it has complied with Section 13 of the Freedom of Information Act of 2011. I remember a few months ago, the House of Reps invited the DG, DM, myself for an interactive session, and they emphasized seriously on compliance with the Act. And fortunately for us, we've been very compliant, and DG was proudly showing evidence of our compliance with the Act. And we hope to go back later this year. We have more evidence of compliance we should show to the House of Reps. On this note, in the absence of any, I don't know whether I have any comments, questions, before I invite the Director of Administration for his remarks. Any comments, questions, appreciation, any reaction at all? Okay, in the absence of that, I wish to...
I think we should pick one from each group as my own assessment, so that I can say when the teacher finishes teaching and there's no question, it's either they understood everything or they understood nothing. So let me know.
Petrus, Deputy Director of Administration, for his remarks, closing remarks.
Yeah, thank you very much. Let me start, since nobody was ready to appreciate our speaker. I want to assure you that we appreciate you. You know, it's just that I believe that the last portion of this presentation was talking about laws, and Nigerians, we don't like laws.
Okay, that was why there was no question.
Yes, because people are beginning to get afraid whether somebody is going to go to jail or something. So, but that's an enlightened note, and we believe that we all got the message. I think it's worthwhile for the management to have organized this kind of, so nobody will claim that they did not know. Now you can see that the selection for representation here were almost like everywhere in the institute. So those of us who have the opportunity to be here, please pass this message down the line so that your colleagues who are not here will get the message that we have one new sheriff in town who is checking what we are doing. So on that note, we want to appreciate the speaker, even in fact our own dear lawyer, Barrister Andrew, who has been following up on this, and you can see why he told us that the institute is in compliance. I think we need to appreciate the institute by clapping, because they told us here that out of 200 and something, NIMA is about 38 or so. 35, so you can see that means we are not doing badly out of that number. So we thank the management of the institute for complying with government regulation. Lastly, I want to again urge us to give a rounding applause to our presenter, and we wish you well in your future endeavors. Thank you very much.
Of attendance. And The certificates will be handed over to the Director of Administration, ably represented, which will be distributed to attendees later.
Alaji, sir. On behalf of Ask Legal Services, we present this certificate of participation to the 75 members of staff of the Institute who attended and participated in the 5 sessions of this training. Congratulations.
Before we rise for the national anthem, I want to lend my voice to that of the DA in appreciation. Firstly, I thank immensely the management of the Institute, ably led by Professor Babatunde Lawal Salako, for its disposition in complying with laws and regulations. This training is, like I said earlier, is statutorily provided, and the Institute can canvass many reasons why it's not convenient for it to conduct it. But the DG has always defied every odd, every inconvenience to ensure that we comply with the Act. So I thank immensely the management. Secondly, I thank you. In addition to thanking you, I congratulate you for making it to this training. 75 out of the whole NIMA staff were selected for this training. So I congratulate you for making it to this training. It's a rare privilege, and one of my teachers always tell me that I should not take granted any learning opportunity. That it may not be useful for me today, but certainly I will find it useful in time to come. So once again, congratulations. Finally, I thank the facilitator for this lively, this informing training. Of course, the firm is a renowned one, so I'm not surprised with the performance. So on this note, I thank you and wish us safety as we retire to our various destinations. Please, may we be upstanding for the second stanza of the national anthem.